Sometimes an entity holds title instead of an individual, such as companies. Sometimes that's a limited liability company or a corporation. Sometimes it could be a trust or an estate. Whenever this happens, our biggest focus is usually on identifying who has the authority to sign on behalf of the entity. We need to know who's that human who can sign all of our documents, be it a deed, a contract, for that entity, that company, that trust, that estate, whatever it may be. So now we need to know, how is our closing process different than when you just take title as an individual? We don't just have Sally, we have Sally's LLC. So number one, we're going to need some formation documents. We need something that's going to prove that this entity was actually created and that it's a valid entity. It was formed. The next big thing we usually are going to need is documentation showing who can sign on behalf of that entity. The fancy term we use for this is signing authority. So you may also need to consider that you have additional parties involved. Maybe your client has an attorney who formed the LLC and they're going to review documents. And then maybe we also even need a court order. So maybe we have a probate estate and now we also need a court order to approve our sale. Another really big one is, what's the correct tax ID number or TIN that my seller needs for this entity? Can they use their social security number or do they need a tax ID number for their entity? Maybe I also need to adjust my contract terms in my purchase agreement. Is my client comfortable with our standard contract terms or do we need to make some adjustments? And lastly, but definitely not least, we really need to consider our timeline. So are we going to be able to close as quickly if we just had an individual in title? Or is it maybe going to take us a little bit longer to gather up all of this documentation and figure out all this information that we just mentioned? A common entity that we see hold property is what's called a trust. So a trust can actually own property just like a human can, or any other entity like an LLC. So the first question we should ask is, what is a trust? So a trust is an entity that's created between two different parties. They have an arrangement. There's a fiduciary. We usually call this person a trustee here in the state of Michigan. This fiduciary is going to hold on to assets on behalf of the beneficiary named in the trust. That beneficiary is the person who's going to benefit from the trust. So we know what a trust is, but how do I know if this property is held in a trust? Well, it's very simple. We're going to look at that deed and we're going to see who the grantee is listed on the deed. The grantee would tell us that the property is held by the trust. So instead of the deed being from Bob to Sally, it's going to be from Bob to Sally as the trustee of Sally's trust. So another question that we want to ask ourselves, why are we putting this property in a trust? Why do we want to have a trust hold the property? So usually when our clients are using a trust and they're deeding the property into the trust, this is a method of estate planning. So by creating this trust and deeding the property into the trust, now you have an entity holding title. And so that property becomes trust property instead of property owned by that human. Once the property is deeded into the trust, that property is managed by the trustee for the benefit of the beneficiaries, according to how the rules created in the actual trust documents tell us. Otherwise, if an individual owns property at the time of their death, that property would be part of their estate. That means they would have to open up a probate estate, go through probate proceedings to confirm and determine who can then deed the property. If instead an individual puts that property into a trust, when they pass away, that ownership doesn't change. Whomever the current trustee is simply refers to the trust documents, and then they are able to manage the property according to the rules set out in the trust. No need to go to probate court or do any of those items. So how do we determine how trusts are managed, created, etc.? So Michigan Trust Code is actually going to tell us exactly what we need to do, how trusts are created, what we can rely on, what documentation it is that we need. So remember, one of our important questions we need to look for an answer to is, how do I know who can sign on behalf of a trust? And Michigan Trust Code tells us that we can rely on that trust document itself, but man, that trust document could be 150 pages. It could have social security numbers in it. It could have some very personal, private details. And people may not want to hand that special binder over to somebody they don't know just to determine who has the right to sign on behalf of that entity. That trust may also change. It might be old, outdated, could be 20, 25 years old. So what is it that we can use to confirm today who our signer should be? Well, Michigan compiled laws tell us that we can rely on a certificate of trust. So that certificate of trust is what is going to tell us who can sign, and it's going to give us some really important information about that trust. Michigan compiled laws, also known as MCLs, 700.7913, it sets out exactly what needs to be contained in that certificate of trust. Our certificate of trust can't just be a document that says, Caitlin's trust document, Caitlin can sign. That's not enough. That's not what we need. We've got to follow the compiled laws in the state of Michigan, and we have to include all the important information. We've got to follow their rules. So first and foremost, it's going to tell us who the current trustee is. It's going to tell us who the correct signer is. It's going to include the name and the date of the trust, names and addresses of all the trustees, again, including the current trustee. It's going to tell us the powers that trustee has. Can they sell property? Can they not sell property? It's also going to list whether or not the trust is revocable or irrevocable. If you have multiple trustees, let's say you have brothers and sisters acting as trustees, that certificate of trust will tell us if they both have to sign or if only one of them has to sign. And then we also want to remember that usually when we're dealing with real estate, we want to record these documents. So that certificate of trust likely has to be in recordable format. We want to make sure that we can record it. The next big question is, how do I get a certificate of trust? Well, we have a lot of options. Our current trustee can always create that document. They can sign it. And a really common thing to do as well is to go back to the attorney who created that trust. And that attorney likely has one already created or can create one for our clients very quickly. So our next big question is, how do I get my property in a trust? What does this look like? How do we get here? So first, it usually starts with an idea. Somebody says, hey, I would like to put my trust or my property in my trust, either for estate planning purposes or otherwise. And it usually also starts with an attorney. In the state of Michigan, trusts can get a little bit complicated. A lot of people like an attorney to prepare that trust for them, ask a lot of questions, and then they'll prepare that document. And those trusts range from a couple pages long to hundreds of pages long. And that settlor, the person who is the one creating the trust, is going to write it down. It's going to get signed. Now, the next step is really important. The trust has to get funded. That means we actually have to deed property into the trust. If I, as Caitlin, own property, and I also have a trust, it doesn't mean my trust is being used to hold that property. My property is not inherently in the trust. I have to actually deed the property into the trust. We have to fund it. Now, if I don't own the property yet, and I want to just purchase it in the trust, I absolutely can do that. It can go straight from my seller right into my trust. There can be some complexities when we get lenders involved because lenders may not want to loan money to a trust per se. Either way, the property has to be deeded into the trust. Once the property is in the trust, Remember, it's the trustee who can act on behalf of the trust. So that purchase agreement, deed, etc., that trustee is going to be the person who's signing those documents. Now, we get back to our initial question, who the heck is our trustee? Who can sign on behalf of the trust? What do I need for my closing? Remember, that's where we're going to go back to our certificate of trust. We're going to look at our certificate of trust, and we're going to be able to see who our trustee is. And Michigan compiled laws tell us that we can rely on that certificate of trust to provide us with that information. So my property is held in a trust, and we want to close this property. My seller wants to sell their property. We know it's held by a trust. What am I going to need to do? Number one, remember, I might need that certificate of trust, and it's probably going to need to be up to date. It depends on the scenario. We might need one that's executed within the last 6 months, last 12 months. But we always know we're going to need that certificate of trust most likely. And another important thing to remember is that in Michigan, there's no registry for trusts. We can't look up and see who the signer is or even who, quote unquote, owns or created any specific trust. So that documentation, that certificate of trust, that trust document itself is very, very, very important. There's really not a lot of replacements for that. So as I'm preparing for closing, I know I need to know who's signing. I probably need my certificate of trust, but I'm also going to review my purchase agreement. I'm going to make sure that when I'm initially talking with my client, we know all of our terms in the purchase agreement that may become an issue for our trustee. The first one we want to look at is our deed. So if we're dealing with a trust, the person who's signing on behalf of that trust, the trustee, may not actually have any knowledge of the property. They may not be comfortable giving a warranty deed. They may want to give a different type of deed, and they may not want to sign a warranty deed. We want to have that conversation on the front end when we are signing our purchase agreement. Now, the next thing we want to think about is the title insurance. Are we offering or agreeing to provide title insurance with or without standard exceptions? If we need to provide title insurance without standard exceptions, there's going to be additional affidavits and documents that have to be signed by the seller, who, remember, is signed on behalf of a trustee. And again, we want to make sure that our trustee is comfortable answering a lot of these questions that are very property specific. So if we know that our current trustee who's signing all the documents doesn't have an intimate knowledge of the property, we want to make sure that we are offering to provide the correct type of policy based on our client's comfort level. Now, the next thing we're going to need is, what is our tax ID number for the trust? When our seller goes to sign that 1099-S, we have that trustee signing that document. We want to make sure that they're prepared. They know what the tax ID number, either for the trust is that they're going to use, or if they're going to use their own Social Security number. We want to make sure that they're prepared to have the right number available at the time of closing. And another big thing we want to make sure that our client is prepared for is at the closing, if that trust is getting proceeds because they're selling the property, we need to make sure that they've got a bank account in the name of the trust, right? Because that proceeds check is going to be made out to the trust, or those funds are going to be wired to the trust. We want to make sure that they have a bank account set up in the name of the trust. And then another thing we want to think about, and really the last item, we want to just make sure is on our radar. We know an attorney is usually involved with a trust. We've maybe used them to prepare the certificate of trust. They may have been involved in the process. We want to know on the front end if that attorney needs to do a document review. We want to make sure that we're setting the appropriate expectations. Do we need some extra time to review those documents? Do we want to try to get documents over to that attorney as early as possible, just to make sure that we don't have to delay closing for that? A common entity that we hold property in is different types of companies. And there's a few different kinds. We've got limited liability companies, we've got corporations, and we have partnerships, to name a few. There's a lot of different kinds. But each different kind of entity has their own formation documents and signing authority requirements. So different things that we need to look at to determine whether or not that company was properly created and whether or not our seller can sign on behalf of that entity. So how does this work? Well, again, we're going to look to Michigan laws, and more specifically, we're going to look at the Michigan Corporation Act and the Michigan Limited Liability Act. Our Michigan laws tell us, and they dictate the process for how a company can be created and managed. So once again, how did we get here? How do we end up with a property being held by a company? Well, usually it starts with an idea, right? Somebody has an idea that maybe they would like to have a little bit of separation from their personal property, or maybe privacy from an ownership standpoint, and they want an LLC or a corporation to hold this particular piece of property. So oftentimes people can employ attorneys to create this entity on their behalf, or they can do it on their own. And so what's the first step in creating that entity? Well, first, you have to get it registered with the state of Michigan. So you're going to pick a name, pick an entity type, and then either file your articles of organization if it's an LLC, or your articles of incorporation if it's a corporation. And so they have to be filed, and you can't just submit them in, they also have to be accepted by the state of Michigan. Your company is not a valid entity until the state of Michigan has confirmed that entity has been created. It can take anywhere from a couple of days to a couple of weeks. So we want to make sure that we keep that in mind. And so once you have created this entity, it's a valid entity in the state of Michigan, next we're going to finish our corporate documents, such as an operating agreement or bylaws. These documents are not as regulated as articles of organization or articles of incorporation, which are for the most part a simple form. Your operating agreement and bylaws can be as short or as long as you want them to be. And these are the documents that are going to tell the public, tell everyone who can sign on behalf of that company, how that company is managed, how decisions are made, and all of that. Now, that operating agreement, those bylaws do not get published in the state of Michigan. They are not public record. So if you want to know who can sign on behalf of an LLC, there is no place where you can just look that information up. You can confirm with the state of Michigan that it has been registered and that it's been created, but that company's operating agreement or bylaws won't usually be publicly available. Let's take a look at limited liability companies. So when we're talking about entities that can hold title, limited liability companies or LLCs are one of the most popular kinds. They're simple and easy to form, and they're very easy to manage on a paperwork standpoint. So what do we need to do? The first thing we always want to think about is that LLCs are state-created entity. They're generally not recognized by the IRS. They're classified as a disregarded entity. So why does that matter? It certainly matters for tax filing purposes. You've got to pick a method and stick with that, and you have to choose how you want to file your taxes. However, from a real estate perspective, if you have federal tax liens and you have a sole member LLC, oftentimes people believe that because the property is held in an LLC, that those federal tax liens don't attach to the property. But because that sole member LLC is classified as a disregarded entity with the IRS, those liens against you personally also attach to your sole member LLC. So when we're dealing in real estate, we actually do care a lot if the property is held by an LLC, whether or not it's a sole member LLC or a multi-member LLC. And as a friendly reminder, when we're talking LLC, we're talking limited liability benefits, right? That's the whole name behind it. So a lot of times there is some confusion and everyone thinks that multi-member LLCs and sole member LLCs share the same benefits, but they in fact do not. So as we're dealing with LLCs that are holding title, what are some of the things that we want to look for? Number one, we want to make sure that it's active and in good standing. How do I do that? I'm going to look on LARA, right? I'm going to look on LARA, which is the Michigan entity that keeps all of that information. I'm going to be looking for articles of organization. I'm going to be looking to see if it's member managed or manager managed. And one of the things I can see on that article of organization is who is the registered agent. Now, so frequently, people misunderstand the significance of a registered agent. And the true use of a registered agent is so that on public record, we are telling everyone in Michigan, if you want to sue this LLC, this is the person that you have to serve. The registered agent is purely a person located or an entity located in Michigan where that LLC can receive service. It does not mean that they are the signer. It does not mean that they own the company. It's just a place where you can serve legal documents to on behalf of that LLC. Now, as we're looking at our LLC, remember we're evaluating, is it a sole member or a multi-member LLC as well? So if it's a sole member, that really means there's only one member. That should be our signer. And again, Michigan laws tell us that if it's a sole member, we actually don't have to have an operating agreement. So we may sign something like a sole member affidavit, but the LLC is valid even without an operating agreement if it's a sole member LLC. Now, on the flip side, if it's a multi-member LLC, we need an operating agreement because we've got to still determine who can sign on behalf of that LLC. Is it one person? Is it three people? Is it a manager? Who is it? So we want to make sure we know, is it a sole member LLC or is it a multi-member LLC? The next type of entity we want to look at are corporations. Corporations are another entity that are regulated by the state of Michigan. They are recognized by the IRS, and all of our corporations have to be registered with the state. You can check LARA just like you would for LLCs. And we're again looking on LARA to make sure that they are active, in good standing, but we're looking for articles of incorporation now instead of the articles of organization. We're also looking for bylaws now. Bylaws are going to tell us who can sign on behalf of a corporation. So a corporation is not going to have an operating agreement. A corporation is going to have bylaws. If a company is holding a piece of property, what are the things we need to think about as we're preparing for closing, as we're getting ready to have our purchase agreement signed? Number one, who's going to sign my purchase agreement? I'm going to need to know who has the authority to sign on behalf of this LLC or corporation. So who are the authorized signers? And in order to see who the authorized signers are, remember we're going to need an operating agreement or our bylaws or bylaw resolution, something to that effect. We need a document showing that our seller, the individual standing in front of us, is able to sign our purchase agreement and subsequently deeds and closing documents. We also want to make sure that that entity was correctly created. So we'll want to check public records, want to check LARA, make sure we've got our articles, either our articles of organization or articles of incorporation. As we're preparing our purchase agreement and we're looking at our negotiation terms, we want to make sure that we're reviewing the type of deed that is issued. So if we have an LLC or a corporation in title, there's a chance that the person sitting in front of us who's getting ready to sign this purchase agreement has never lived in that property. So we want to confirm, are you comfortable signing a warranty deed? because our purchase agreement is going to dictate the type of deed that is provided. So before we sign a purchase agreement and agree to a deed, we want to make sure that we have that conversation with the client. Are you comfortable signing a warranty deed, or do we maybe want to provide a covenant deed? And then we also want to consider the type of title insurance that we're providing and whether or not we'll be providing a owner's policy with standard exceptions or without standard exceptions. If we're providing a policy without standard exceptions, there are some additional affidavits that our seller is going to need to sign. And again, if they have never lived in the property, they may not be comfortable signing off on all of that information, and it may be a better option to offer a policy with standard exceptions. The next thing we want to think about as we're preparing for closing, we're working with our seller who's holding property in a company, is what is the correct tax ID number or social security number that is going to be used at the time of closing for that 1099-S. So is this a pass-through entity? Is it maybe an LLC and the seller is going to be using their own personal social security number? Or is this an entity that has its own TIN? We want to make sure we know what that TIN is before the closing. We want to get our client prepared. We want to make sure that they have that tax ID number available and ready. And another thing we want to think about is making sure that our client has a bank account in the name of the company. So at the time of closing, when our seller is going to get their proceeds, we need to make sure that they have a bank account that they can deposit that money into. So make sure that they have a bank account in the name of the company. Sometimes as we are helping our clients sell property, we find that the property is held in this weird thing called an estate. What the heck is an estate? So an estate is actually the totality of a person's assets. It's everything they own. That's a very general term. In the state of Michigan, we have this thing called the probate court that handles administering estates for people. And generally, when someone can no longer make decisions for themselves or their property because they have either passed away or they've become incapacitated, their estates, all of the things they own, need to be what's called probated. So this is the formal legal process where a court is going to review their estate, review their circumstance, whether they passed away or became incapacitated, and they're going to approve, confirm, appoint a person who can act on behalf of that person that was deceased or incapacitated. So the court is going to determine and decide that this person cannot handle the assets that they own, and then decide on who can do that for them. And that person that they appoint is what we call a personal representative. So now that personal representative is who is going to act on behalf of that estate. And now let's talk about the different kinds of estates we have, because there's more than one, which is a common misconception. So the first type of estate that we can have is a decedent's estate. A decedent's estate occurs when someone passes away, and obviously someone else needs to facilitate sales or management of their property now. Another type of estate is a conservatorship. So a conservatorship is created when someone becomes incapacitated and they need someone to help make big decisions, and usually we're talking about financial decisions. And another type of estate that can be created is a guardianship. A guardianship we see a lot with younger individuals, and that guardianship is focused more on helping people make decisions about their personal well-being and their health. So when we're dealing with real estate and we're dealing with estates and probate, we're really dealing with conservatorships and decedent estates. So we're dealing with people who have passed away and can no longer deed their property, and we're dealing with people who've become incapacitated and can no longer deed out their property. So it's important to understand how title works So we know why estates get a little bit complicated. So we talk about this thing called a chain of title. And a chain of title is going to link every grantor and grantee to the next. So from Adam to Bonnie, and then Bonnie to Carol. Now, what happens if Bonnie passes away? You can't go from Adam to Bonnie and then magically to Carol. You also can't go Adam to Bonnie and then Ryan, who is Bonnie's second cousin, to Carol, right? You need to have some legal authority to tie those two deeds together. So Bonnie still needs to deed out and eliminate her interest. We've got to keep that chain consistent. So Ryan, if he is the correct person, needs the correct legal documentation to show that he's signing on behalf of Bonnie. So in order for us to understand probate, we really need to take it back a step and make sure that we understand tenancy as well. So a quick reminder, joint tenants with full rights of survivorship, right? That looks like Sally and John as joint tenants with full rights of survivorship. If John passes away, that means that Sally owns the property. So if you have joint tenants with full rights of survivorship and one passes away, the other has full legal title. We don't have to have a probate scenario because title passes from the deceased person directly to Sally, our original person, due to tenancy. Right now, what happens if in that same situation, Sally passes away too? She passes away second. So how are they going to deed that property out? Well, now is when probate comes in, and Sally is going to have an estate opened and have her estate probated. And then her personal representative will need to sell. Not John's. We've already eliminated John's interest. Just the surviving joint tenant has to open up an estate. And then we look at tenants by the entireties, and we know tenants by the entireties works the exact same way. The only difference is the two parties have to be husband and wife, right? So that's going to go the same way if Sally and John are husband and wife. Again, if John passes away, the property will go to Sally. And if later Sally passes away, it'll be Sally's estate that gets probated, not John. Now, in the state of Michigan, tenants in common is actually the presumed tenancy. So if you don't write Sally and John with joint tenants, full rights of survivorship, it's presumed that Sally and John own property as tenants in common. So if Sally passes away, so Sally's interest has to be probated even though John is still alive. And vice versa. If John passes away, John's interest has to be probated and his personal representative has to sign. No interest gets eliminated and passed on to the other. So you could have a scenario where you have Sally's personal rep signing and John's personal rep signing, and you'd have to have both estates probated. Now that we know when we have to get probate involved, the real question is, how does probate work? How do estates work in Michigan? Well, estates work in Michigan based off of this thing we called EPIC. And it's not that exciting. It's really the Estates of Protected Individuals Code. So again, we're talking Michigan compiled laws. So how do we end up with an estate and title? How do we end up with this? Well, first, there has to be something that happens to this person who owns the property. Sally owns the property. She unfortunately passes away, or she becomes incapacitated. And that means you usually end up with a death certificate or some doctor's notes, things like that. Then usually in the state of Michigan, we are going to hire a probate attorney who is going to do all of that work of doing what we call probating the estate. So they're going to help you navigate this probate process. They're going to fill out the paperwork, the court mandated forms. They're going to gather all of the information. This could be super, super complex and involve many interested parties and maybe lenders and creditors and 10 children. and 100 properties owned by Sally. Or it could be super, super simple. And maybe Sally has one daughter and one property, and it's just a little bit of paperwork. And then that attorney, or you could do it on your own, but usually people use an attorney, is not only going to fill out all of that paperwork, but they're going to help with any actual court proceedings. You may need to appear in front of a judge and have that judge is actually going to sign off and appoint that person that we refer to as the personal representative. And that personal representative is who can sign on behalf of Sally. So the court is going to issue this thing called letters of authority. Those letters of authority appoint that personal representative. It lists their name on there. So Sally's daughter cannot sign anything on behalf of Sally's estate without those letters of authority. Those letters give them power. Now, whether you have a decedent's estate with a deceased person, or you have a conservatorship with an incapacitated person, either way, the document that you're looking for is called letters of authority. And in both scenarios, the person they're appointing is called the personal representative. When we receive those letters of authority, we do want to be careful. It's going to tell us who can sign on behalf of that estate. It's also going to tell us if there are any restrictions. And what is a restriction? Well, it's something you can't do. So sometimes it will tell us that they can't sell property, or maybe they can't sell the property that incapacitated person is living in. But we don't just want to say, yay, check the box, I got my letters of authority. We want to also read them and make sure that they're not restricted from doing something like selling the property. Now, it's not super uncommon to see restrictions. If you do have some restrictions and those letters of authority say Sally's daughter is the personal representative, but she can't sell property, well, we do have options. What's going to happen is that probate attorney is going to have to go back to probate court and get a specific court order allowing the sale. So the personal representative will get that court order, and then they will be allowed to sell the property. We do need to be careful, because if we have a court order, oftentimes we need to be careful of this thing called an appeals period, which is a time period in which that court order can be appealed. So we have to do what's called observing that appeals period. We've got to wait out that time frame to make sure that no one is going to object to that court order, and then we can rely on it. So I know that I have an estate and title. What do I need to think about when I'm getting my purchase agreement signed and preparing for closing? So first and foremost, we have an entity and title. We need to know who can sign on behalf of this entity. And because it's an estate, whether it's a decedent's estate or a conservatorship, we need to know who the personal representative is. So I must have valid letters of authority. If you don't have letters of authority, you don't have a power to sign. Next, I'm going to look at my actual purchase agreement. Do I have terms that I need to evaluate in the purchase agreement when I'm dealing with an estate? The answer to that is yes, absolutely. What type of deed is my seller comfortable giving? Again, if you have someone who's sitting in front of you ready to sign a purchase agreement, we want to have this conversation. Are you comfortable giving a warranty deed? Have you lived in the property? Are you familiar with the property? Do you feel comfortable giving that warranty deed? Make sure we know that before we sign the purchase agreement promising to give the warranty deed. Next question we want to ask is, what type of owner's policy is being given? Is it with or without standard exceptions? Again, if my client's a personal representative on behalf of an estate, they may not know a lot about the property. They may not be comfortable signing affidavits in lieu of survey or answering certain questions that would be required if we were promising to give an owner's policy without exceptions. So we may need to only offer an owner's policy with exceptions to avoid putting my seller in a position where they're being asked to answer questions that they maybe don't know the answer to. The next thing we want to think about is what social security number or TIN number is going to be used at closing. If you have questions about this when you're dealing with an estate, it's always a good idea to refer to the attorney who's handling that probate estate, but we want our client to be prepared for closing. So we want to make sure that we have this conversation as early as possible. Make sure that the personal representative knows what tax ID number needs to go on that 1099-S at closing. And the last thing we want to think about is making sure that that proceeds check at the time of closing, remember it's an estate selling property, so the proceeds have to go back to the estate. So we want to make sure that they have a bank account for the estate. So when do I think that an estate may be involved in my closing? So if I have a trust in title or I have an LLC in title, which are some other common entities, it's usually really clear because someone had to deed the property into the trust or deed the property into an LLC or a corporation. We can look at the simple vesting deed to see either is it held by a trust or not. Estates are a little bit more tricky because usually people take title and then something happens to them while they own the property. Either they become incapacitated or they pass away, and now their estate holds title. So how do I know? How do I know if that circumstance has happened? Well, I want to make sure that I'm asking my clients questions. Is the person standing in front of me trying to list this house? Are they telling me it was their parents' home and their parents passed away? Are they telling me that maybe their parents are incapacitated? If they're giving us any of those clues, we want to ask, do you own the house or did your parents own the house? Is this a probate situation? Is this a deceased individual? Is this a conservatorship? And then we want to ask some questions about where my client is at in the process. Did you already open up an estate in probate court, or have you not even started that yet? This is a very important timeline question. We want to know how long before we can close the property. We don't want to accept a cash offer that wants to close in 15 days, but meanwhile, my client hasn't even opened up a probate estate, and we know that they've got 9 brothers and sisters, and this might get a little messy, right? That's not a good scenario. We don't want to put ourselves in that spot. Anytime you think an estate may be involved, it's highly recommended that you do something like a pre-title search. Most title companies, Legacy Title involved, we're more than happy to do a quick pre-title search. We'll see, oh yes, it looks like there's a probate estate, it's already been opened, there's already letters of authority issued. Or no, we don't see a probate estate has been opened, we don't have letters of authority, this may take a little bit longer to get what we need for closing. You can also ask the attorney who's involved. That attorney will be very familiar with the actual probate estate if they've already found an attorney and the attorney's been working on it. And they should be able to give us a good timeline too about how long they think it will take to continue to get this estate probated and how long it'll take until we have good letters of authority that we can use to close the transaction. Another fun thing we have when we're dealing with estates is this concept of self-serving deeds. Here in the state of Michigan, if a fiduciary, such as a personal representative, deeds the property to themselves. So if Sally's daughter deeds the property to herself and then she tries to sell it, that's actually a self-serving deed. That deed where Sally's daughter acted as a personal representative and deeded it to herself, that's a self-serving deed. And in the state of Michigan, the Land Title Standards 7.11-2 actually tells us that after March 31st, 2000, this deed from the personal representative to themselves is not marketable. That means we can't trust it, we can't rely on it on its face, meaning we need additional documentation to be able to utilize that deed. Now, the good news is Land Title Standards give us 3 options. So we've got 3 things we can get in order to be able to trust this self-serving deed. Number 1, we can get an express court order. So we can get a court order from the probate court allowing this deed from the personal representative to themselves, but they do have to give notice to all of the parties and have a hearing. Number 2 is we have to have a will or a contract from that person who has passed away that expressly authorizes that deed from them as personal representative to themselves. So if you have a will that says that Sally really wanted her daughter to have this piece of property and she gave it to her at the time of her death, that would work and that would solve this second option. Or the third option is you can have all of the interested parties consent to that conveyance from the personal representative to themselves after there has been a fair disclosure. So you do generally need a list of all of those interested parties so we know who needs to sign off on that. But you do have 3 options if you do end up with a deed that is what is classified as self-serving from that personal representative to themselves. Whew, that was a lot. Thanks for sticking with me to the end. I hope you learned some really valuable information today. If you've got any questions about your scenario or general questions, feel free to leave them in the comments below or give me a call or email directly and I'm happy to help. If you're ready to work with us, click the link below to start your order. Thanks for hanging out today. We'll see you soon.